Sorry about that.
Well, that's all right. And I get this right. So the appellee's attorneys, have you discussed how you want to divide your 20 minutes?
Yes, good morning, Your Honor. We're going to divide it 10 and 10, and I will speak first.
Okay, great.
May it please the court. I'm Adam Richardson. I represent plaintiffs' appellants in this case. My co-counsel should be listening in. They're Andrew Calandro and Christopher Pettis. And for rebuttal, we'd like to reserve 5 minutes.
Sure.
And as a bit of housekeeping, one of the appellees, Summerfield, filed a motion for attorney's fees today, and we will be filing a response. We just didn't want that to get lost in the resolution of the case on the merits. We're here asking the court to reverse an order of dismissal that was based on an order granting granting a motion to dismiss certain claims with prejudice, and then another order denying a motion for leave to amend the complaint. I'm not going to go through the procedural history or the effects really, except as they're pertinent, but leave should be granted very liberally and freely. That's a very basic proposition of law. It's almost presumptive error to deny leave to amend. And the test is very simple and very permissive. The amendment should be granted unless privilege is abused, the defendant would be prejudiced, and or amendment would be futile. On futility, the test appears to be that an amendment is futile if it's insufficiently pleaded or insufficient as a matter of law. But in the context of asking for leave to amend rather than on a motion for dismissal of state of cause of action, all doubts regarding futility should be resolved in favor of amendment. And it seems that—
Mr. Richardson, can you help me with kind of a preliminary thing before you go through the factors of granting leave to amend?
Yes, sir.
How do we get past the general prohibition that we don't review rulings under invited error? How do we not have, how do we get past that in this case? That's an argument that your opponents have made, and I'd like your thoughts on that.
Yes, sir. As we stated in the reply brief, the rulings that we're challenging are the 2 orders that I mentioned previously. We did not invite those. We opposed the motion to dismiss, and we asked for leave to amend.
You were granted leave to amend, but not to include the claim for emotional distress, correct?
Yes. However, I would note that there were 2 counts, 6 and 7, that were dismissed with prejudice in their entirety because they were only about non-economic damages.
Right.
But the case law actually does allow this procedure even when granted leave to amend. For example, in this court's case, Klein versus Pinellas County, the defendants moved to dismiss the complaint, and the trial court granted the motion as to some counts, but granted leave as to another count, stating that the plaintiff could file an amendment if they could, in good faith, make a certain allegation relevant to the merits of the cause of action. But the plaintiff served a notice of inability to plead, and they appealed. But this court held that the order was not final, not appealable, because the plaintiff didn't do what we did in this case, which was ask for the entry of a final order of dismissal. So in that case, even though the plaintiffs were given leave to amend, they decided not to avail themselves of that. But the court said that had they done what we did here, that the appeal would be final and appealable, and presumably the court would have been able to move on to the merits. Okay, and one of the things that one of the appellees does is characterize this as a consent judgment throughout its answer brief. It's critical intervention. I wanted to point out that a consent judgment is one that's usually reached by settlement, and the parties agree to the settlement of all the claims and then have that formalized in a judgment. Obviously, the judgment here, the order of dismissal, was not reached by any kind of a settlement, again, we oppose the motions and ask for leave to amend. One of the cases that I think is actually pertinent on this issue, Judge Lucas, is something that Critical Intervention cited. It's a 4th District case from 2015, Pacific National Bank versus Home Tower Condo. And the facts there are distinguishable, but the 4th District quoted an 11th Circuit case for a proposition of law that I believe is relevant here. The court quoted from the 11th Circuit case as follows: "The law is clear that consent to entry of judgment without reservation of the right to appeal a particular claim bars an appeal. Where the parties have agreed to entry of an order or judgment without any reservation relevant to the issues sought to be appealed, one party may not later seek to upset the judgment unless lack of actual consent or a failure of subject matter jurisdiction is alleged." So not only did we follow explicitly the procedure that this court and others have advised litigants to follow, but we also fit within that rule in the 4th District case by reserving the right to appeal, essentially, by saying that we wanted to be able to appeal certain rulings of the trial court.
I guess the problem is that in terms of, I use the term reserve the right to appeal, you would have the ability to gain review of the emotional damages issue on a plenary appeal at the end of the day. So it doesn't seem like you were deprived of your ability to, by asking the court to dismiss the complaint with prejudice rather than submit an amended complaint in the fashion in line with the trial court's ruling. You did not say that it was impossible to do so, that you could not in good faith do it. And you did have a way to gain review at the end of the case by plenary appeal. So does that really get you past the invited error problem?
Yes, I think it does, based on the case law. I think just the case law is very clear that this was an avenue that was available to us to take. The invited error doctrine, again, I think if we were attacking the judgment of dismissal rather than to antecedent rulings, we would have an issue. Now, maybe for the invited error rule might apply to the actual order granting the motion to dismiss, but certainly with respect to the motion for leave to amend and the order denying that, I think that that is a ruling that we should be able to appeal in this procedural posture. Now, we did ask in our briefing that if the court believes that we did not take a proper procedural path, that we nonetheless would like a remand to be able to pursue the claims that the trial judge did allow us to pursue. And I think that would be ultimately a fair result, because we were relying in good faith on case law, including from this court, in asking for the entry of an order of dismissal. Does anyone have any other questions on the procedure? May I move on to the merits, Judge Lucas? Okay.
Your time. I appreciate your answers.
I know, but you had questions on that, and I just want to be able to answer those questions. On the merits, as I was saying, it's almost reversible error for a judge to deny a motion for leave to amend. It's leave should be freely granted, and it's almost presumptive that the court should grant it unless certain conditions are met. The defendants don't challenge in this appeal that we've abused privilege to amend or that they would be prejudiced by amendment. This all boils down to futility, which is a fairly lenient standard for us to satisfy. As I said, that with respect to futility, all doubts should be resolved in favor of amendment. The issue here, of course, is whether we're able to plead damages elements of mental anguish and emotional distress. And here we argue that the trial judge got it wrong in the implicit determination that the amendment would be futile. The allegations of the proposed amended complaint clearly fall within the purview of the Laporte case from the Florida Supreme Court. In that case, the court recognized that if the alleged conduct of the defendant were implied malice or exhibited great indifference to the person's property or rights of others, such that malice would be imposed as would justify the assessment of exemplary or punitive damages, then the case falls outside of the operation of the impact rule. The impact rule, it must be noted, applies to negligence claims. And so it makes perfect sense that the court would have said that in cases involving malice or imputed malice, the impact rule would not apply to bar the claim. So in the LaPorte case, just very briefly, the garbage collector threw a trash can at a dog that was tethered outside the house. He actually then laughed and walked away. We haven't alleged that kind of extremely callous behavior, but we have alleged, we believe, in the pros amended complaint, facts that support a determination of malice or imputed malice. Because as we allege, this dog did not bark. There was no indication that the dog provoked Mr. Cashwell. Mr. Cashwell simply fired shots without warning. And then even in response to the shooting, did not do what I think a normal person would do, which is approach the owner of the dog or maybe exhibit some nervousness. Here, as we allege in the complaint, Mr. Cashwell was essentially cool, calm, and collected. He walked away, did not engage with Mr. Zimmerman. Mr. Zimmerman actually had to go get his own gun and sort of detain Mr. Cashwell. Mr. Cashwell, again, did not exhibit kind of nervousness that we would expect. So I think it's reasonable to imply from those alleged facts that the security guard, Mr. Cashwell, acted with malice or at the very least great indifference to the property rights of Mr. Zimmerman by in his injury to the dog. This is not a case where it would involve mere malpractice. So the primary case that the defendants relied on in the trial court and that the judge felt he was controlled by at the motion to dismiss stage was the First District's case in Kennedy versus BS. And that case very clearly alleged only veterinary malpractice. Unfortunately, the specific factual allegations are not within the First District's opinion, but the opinion is clear. The First District's holding was clear. It distinguished between malpractice or negligence cases, such as the facts before it, and LaPorte, specifically distinguishing LaPorte as involving malicious behavior by the defendant. And that's why we believe that the Kennedy case is distinguishable and that the proposed amended complaint falls within LaPorte, and LaPorte authorizes these claims for emotional distress and mental anguish damages. I would note that I think that this case also falls within the Third District cases that we've cited, such as Johnson, Wills, and Levine. And I just want to point out that I think the First District got it a little bit wrong in Kennedy by saying a couple of those cases involved only malpractice and then certifying conflict with those cases. I think a more careful reading of the Third District cases establishes that each of them involved gross negligence or great indifference. Something along those lines is authorized by LaPorte. Unless the court has any other questions, I do believe that I've addressed what I needed to address in the court's questions. And I'd like to reserve the remainder of my time for rebuttal, and I hope not take up the rest of my time. Thank you.
Thank you, Mr. Richardson. Mr. Tinker?
Good morning. May it please the court. Mark Tinker on behalf of Critical Intervention Services and John Doe. And with me is Jason Nazarone on behalf of Summerfield Community Association. I'd like to start with addressing your questions, Judge Lucas, because I think that is a major issue in this case. I'm not sure whether it's called invited error or consent judgment or what the term would be for it. But what Mr. Richardson said is, well, we're not concerned with this final order of dismissal. We're concerned with, the quote was, these antecedent rulings that happened. And these antecedent rulings are non-final orders that Judge Battles entered. They addressed an element of damages, whether that element of damages was available, did not deprive Zimmerman or Hill of any causes of action, just addressed an element of damages. And Judge Lucas, we cited to one of your opinions in Florida Farm Bureau versus Peacock's Excavating, where you looked at a situation where there's a non-final order like this, and you said the court cannot create jurisdiction for the sake of expediency. And that's what Zimmerman's trying to do here. They have these non-final orders. They think that they're pretty critical to their case. They're very important to them. They would not allow for immediate review. They're not within the scope of Rule 9.130. There's no ability to seek certiorari or any other form of review over them. So they try to create appellate jurisdiction by asking the trial judge to enter a final order of dismissal for the express purpose of appealing these antecedent rulings, these non-final orders. And that is something that the court should not allow, and that the rules do not allow, is essentially promoting piecemeal appeals, promoting successive appeals. And frankly, I don't know, your quote, Judge Lucas, was that it would be allowing for jurisdiction for the sake of expediency. I don't even know if it would be expedient in this case, because the purpose of requiring parties to wait for plenary appeal, to wait for final order, is so that the court can resolve everything at once. Here we have very questionable issues of liability that would have to be proven, especially when you look at the vicarious parties at critical intervention, and even more so, Mr. Azarone, I'm sure will tell you, for Summerfield. There are very questionable liability issues that would have to be established. There could be many other things that could arise during this case. There could be an improper jury instruction given at trial. There could be a surprise expert witness. There could be anything. The point is that the court should be able to review any alleged error at the end of the case, not allow parties to say, well, this happened right at the beginning. I think it's pretty important to me, so I want to create immediate appellate review over it. Again, Rule 9.130 does not allow for that. Litigants can't just bypass the rules to do indirectly what they're not allowed to do directly. And I believe that's what's occurred here. That is really the main point that I wanted to address. I know we're in a little bit of a different posture because I do represent John Doe, who is the personally involved defendant. I think there's a lot of other issues as far as whether this proposed amendment or even the causes of action could state a valid claim against the vicarious parties. As to my client, critical intervention, even the proposed amended complaint is attempting to assert dangerous instrumentality for a firearm, and the case law says that a firearm is not a dangerous instrumentality. So I don't believe there's a valid claim there. The negligent hiring and retention claims that are alleged, even in the proposed amended complaint, don't allege any facts that would support those claims. That a background investigation would have revealed something, a fact, something specific that would have made this a negligent hire. There are issues as far as even the respondeat superior claim that's alleged against critical intervention just says, well, this gentleman was working. But as Mr. Richardson just said, the alleged claims are to say, well, he committed an intentional act with malice, is what they're attempting to prove. That's not within the scope of employment for a security guard, is to intentionally display malice towards the residents that he's trying to protect. So I don't believe that a vicarious claim would exist there either. So I'm going to defer most of that to Mr. Azarone, because I know he believes that there's amendment would be futile, that no valid claims could be asserted against his client. But as to any of them, as to any defendants, I don't believe that the procedure, the posture that has brought the case before this court is proper. Whether it was a consent judgment, invited error, this is a judgment that only exists because the plaintiff asked for it over defense objection, which is kind of an unusual thing. When the plaintiff pointed out that this is what they were attempting to do, they sent a letter to Judge Battles saying, we want you to enter this so that we can appeal it. The defense said, no, you shouldn't do that. That's improper because you have these valid claims. You haven't agreed to dismiss them. Mr. Richardson, in both his briefs and again here today, has asked the court to say, well, if you disagree with me, go ahead and remand the case back so that we can pursue our property damage claims, the claims that they could have been pursuing all along, the claims that everyone agrees existed at this point, were it not for them asking for a final order, getting rid of them, dismissing them all with prejudice. So they're attempting to say, let me take an immediate appeal of this issue. If you disagree with me, send it back and let us do what we should have been doing all along. That's improper. We don't believe that the court has anything to review because Judge Battles didn't issue a ruling that was an error. He did exactly what the plaintiff asked him to do and demanded that he do over defense objections. So
Mr. Tinker, and I know it's may seem like kind of an esoteric question, but it does tie into what you just said, which is that the idea of affirming and remanding with some kind of instruction does seem unusual. You say it's improper. Why is it improper in your view?
it's improper because it's allowing this appeal to exist as an appeal of those non-final, the antecedent rulings is the quote, to say, well, let me get immediate review over these. And if you disagree with me, then I've had my interlocutory appeal, send it back and I'll continue with my litigation. It's improper because those claims have been dismissed by the remaining claims that they're asking you to remand for were dismissed at the request of the plaintiffs. The judge would not have dismissed them. He didn't dismiss them. He granted leave to amend for them to reallege those claims. The defense agrees they were probably valid claims. They were dismissed because the plaintiff asked them to be dismissed. So those are invited error, consent judgment, whatever the term might be for those. If you don't have any other questions, I'll yield the rest of my time to Mr. Azzarone, and thank you.
Thank you, Mr. Tinker. Mr. Azzarone.
May it please the court, Jason Azzarone on behalf of Summerfield Master Community Association. I'd like to address Judge Lucas's question. To allow the appellant to go back essentially argues that, well, we did have a way to go forward before. The procedure that the appellants took in this case essentially requires them to say, we do not have the means to file an amended complaint. That is why we need the immediate review. So what we have here now is the appellant saying to the trial court, we can't go forward. Please enter an order dismissing the matter with prejudice, which the court did, the trial court did over objection, like Mr. Tinker said. And now they're saying, well, if you don't agree with what we did, send it back and give us a second bite at the apple. But if you look at the procedure from the case law, it says you have to be unable to file an amended complaint. And that's not what happened in this case. Appellant's counsel in the briefs goes to great lengths to say, well, you should allow amendment freely. That's what the trial judge did in this case. We asked him to dismiss only the claims for emotional distress damages because emotional distress damages in this context are not available for damages to property. Florida law is consistent on that. Appellant's counsel below, plaintiff's counsel, was asked by the judge, how do you get around Kennedy? And the only argument we've heard thus far is Laporte controls. There's never been an answer. How do we get around Kennedy? How do we get around the fact that you do not get emotional distress damages for simple negligence claims? So for the appellant to come in today and say, Judge Lucas, if you don't agree with us, please let us go back. That's not proper. And I mimic what Mr. Tinker said. We shouldn't allow them to get an intermediate ruling so that they can then go back and continue with this case. They chose this route. And if it goes forward and this court affirms, which we think this court should do is affirm the trial court's decision, then that's the end of the case because that's what they wanted. They asked for the end of the case. On the futility argument, I disagree with appellant's counsel. It's clear in our brief the reasons why. I won't go into all of them. However, in the proposed amended complaint, you note again that all of the claims listed are for simple negligence as to my client. And that was what we argued in the response to the motion for leave to amend. For the most part, and counsel's arguments in his reply brief was, well, you didn't look at the additional facts. No, I did look at the additional facts, but what I looked at was the core facts, and the core facts never changed. The core facts were that the gentleman, the security guard, was approached and unfortunately discharged his weapon, striking the pet. Appellant's counsel, plaintiff's counsel below, has implored the court below and this court to find that discharging a weapon is automatically malice, automatically done grossly negligent. And that's just not the case. It could be done permissibly, it could be done non-negligently, or it could be found to be negligent without going to the extra step of gross negligence. So again, everything we've seen in this case as pled, as to my client, alleges vicarious liability for which there is no claim under these facts, or simple negligence. I think the most important thing for the court to recognize is that the plaintiff below was given the opportunity to proceed with this case and made the voluntary decision to not go forward. So we would ask that the court affirm the decision of the lower court and the dismissal of the case with prejudice. Thank you.
Mr. Azarone, Mr. Richardson, you're up. You have 6 minutes.
Thank you. I'm going to hit just a few points, I think. First, as I said in the initial argument, this court's Klein case specifically authorizes the procedure we took here. In that case, the defendants were allowed leave to amend, just like in this case where we were given leave to amend. Mr. Azarone says that that's not proper, that we can't just ask for an entry of dismissal, and that's somehow perhaps unfair for us to then give up our claims that we were allowed to pursue. But that's exactly what this court allowed in Klein. And that case controls as to the procedure here. Now, if the court believes that Klein was incorrectly decided or that the specific advice that the court gave to litigants in that case is incorrect, then the proper course would be for this court to recede from that case. Of course, that is completely within this court's authority to do that. But the law as it stands now authorizes what we did here. If the other liability issues and counts, whether they're sufficient, there are a number of counts in the proposed amended complaint, and they need to be fully briefed. If the court were to reverse and remand, instructing the court to grant our motion for leave to amend, then the defendants would be able to file a motion to dismiss for failure to state a cause of action, and then those issues could be fully briefed. Finally, first, Mr. Azarone said that the plaintiff needs to be unable to amend the complaint to be able, I guess, to avail themselves of the procedure in the case law. But that's an incomplete statement of the law from those cases. It says, for example, in Augustin versus Blunt, if claimant is unwilling or unable to amend. So it's not inability, it's also an unwillingness. I think here it's very clear that we are unwilling to amend the complaint within the trial judge's instructions. The final point I would like to make is on our fallback request for relief, which is remand. There is no case that I'm aware of that holds that our request is improper. I think that would be something this court would be determining in the first instance. But I also think it's very important that court remember that fairness is a big motivating factor in the law. And here we relied in good faith on this court's decision in Klein and the first district's decisions in Augustin versus Ponton. If that good faith reliance on those cases was misplaced, then it's only fair that we be able to go back and pursue the remaining claims. It's just, there's nothing improper about it. There's no convincing explanation that's been offered for why that's improper. We simply followed the path that this court and others have laid for us. And unless the court has any further questions, that is the conclusion of my presentation, and I thank the court for its time.
Thank you, Mr. Richardson. Thank all of you. In order to leave our virtual courtroom, you click the button called, of all things, Leave.